In this video, we'll talk about a recent lawsuit that essentially forced UCIS to change its policy with respect to the 3 and 10-year bars to inadmissibility. This is a huge topic and is going to impact quite a few people. So if you're interested in this topic, I'll see you on the other side. Hello everybody, and welcome back to our immigration channel. This is a place where you get the most up-to-date immigration news, immigration information, and everything else that you need to make your immigration journey less stressful. My name is Jacob Sapochnick, and I'm an immigration attorney located in San Diego, California, and I help clients in all 50 states and all over the world. In this video, we'll cover a recent lawsuit that essentially forced UCIS to change its policy with respect to how they treat people who are currently inside the United States applying for adjustment of status and are subject to the 3 and 10-year bars. There's going to be some changes, and I'll cover all of them in this video. Before we do that, if you're here for the first time, don't forget to subscribe to our channel, click the notification bell so you don't miss any of our videos, and also give us a big like so YouTube will be able to show this video to more people just like you. As a result of this lawsuit, class action case Gomez versus UCIS, and you can see it right here. As a result of this lawsuit, UCIS is going to change its policy with respect to applicants who are adjusting their status inside the United States and are subject to the 3 and 10-year bars. And basically what it's going to do is the new policy will not force these applicants to leave the United States during their inadmissibility period, as they require them to do until now. Also, UCIS will no longer reject applications for adjustment of status if the applicant was inside the United States, subject to the 3 and 10-year bar, and did not apply for a waiver. The good thing is that previous applicants who were denied because of this policy can now go back and reopen their cases. So let's give you a little bit of background. The lawsuit was filed by the Northwest Immigrant Rights Project, and the class action essentially challenges UCIS's current policy, how they apply the 3 and 10-year rule to applicants who are adjusting their status inside the United States. And essentially, just to explain to you, this policy applies to applicants that came to the United States at some point, either a tourist visa, student visa, or work visa, overstayed their visas, then departed the United States. So essentially, if you overstay your visa by 6 months and then you depart, you're subject to a 3-year bar. If you overstay by over a year and depart, you're subject to the 10-year bar. Well, those applicants that were subject to the bars eventually were able to obtain visas lawfully. They went to the US Embassy years later and applied for visas and got their visas, and then re-entered the United States lawfully. These applicants eventually applied for adjustment of status, and once UCIS found out about their previous overstay and them being subject to the 10-year bar, or they were required to file for I-601 hardship waivers. And there were quite a few cases where applicants were actually denied adjustment of status because they were here during their period of admissibility, whether it was 3 years or 10 years. And so remember, once again, this is only applicable to applicants who came to the United States with a visa, overstayed, then left the United States, triggered the bar, the 3 or 10-year bars, and then re-entered later on with a valid visa and applied for adjustment of status. Those applicants, under the new policy, should be able to adjust their status. They don't need to wait outside of the United States during the period of admissibility or need to apply for a waiver. Now, this does not apply to applicants that are subject to the permanent bar. So if you have multiple re-entries, you came here unlawfully, and now you're subject to a permanent bar, this does not apply to you. This also is not going to apply to you if you obtain your visa by fraud. So for example, you did not disclose the fact that you overstayed, you changed your name, you used a different document, a different birth certificate, whatever you did to obtain that visa to enter lawfully, use somebody else's visa. If you've done any of those things, you're not going to be eligible under this new policy. This is only for those applicants who left, re-entered lawfully, and then UCIS misinterpreted the 3 and 10-year bar. Those applicants were denied adjustment of status or were forced to file waivers. So there's going to be a new policy. It's currently being finalized, and of course I'm going to update you once it's going to be rolled out into the USCIS policy manuals. So once again, hopefully this information is helpful. If you have any questions, let me know in the comments below. If you need my help with any of your immigration cases, you can text me right here, 619-483-4549. Thank you for watching this video, and I'll see you in the next video.